Hi everyone. We're going to bust up this video series into two videos for this week, Chapter 10 and Chapter 17. So let's go through Chapter 10 first, which is a legal environment, and there's a few highlights in here. So there's a lot of we're not going to make you a lawyer overnight. Even contract law itself is an entire semester-long course in law school, so we're not going to make you lawyers. What I am going to point out is some critical elements of certain laws that are important to small businesses, and then we will be quizzed on this later on. There's going to be a quiz, or it will definitely be either a quiz or a midterm on this subject, so, or should say a quiz or a final on this subject. So it's important that you sort of understand the basics of this. And it's also just from a life perspective, these are the sort of things you'll run into, whether it's you're buying a house or you're negotiating a car or a lease or anything like that. These are the kinds of things that you're going to need to know from a legal perspective. And also if you ever hire any employees, I think this can be more Chapter 17, but that'll be some pretty important stuff. So the laws we're going to go over about protecting your rights as an employee, as a business owner, and also protecting property rights that you may have, and things like bankruptcy, which is a reality for a lot of people. So, okay. Some challenges. Laws are not necessarily easy to understand. Very often there's a gotcha someplace in the law. Paperwork. We also call this a regulatory environment or compliance environment. You're required to comply to certain laws, and you're required to put paperwork up for certain laws. So there's some mandated stuff that you have to do, and then there's some cost related to running this. So these are all challenges for small businesses. Some things. This is just a survey that they took a few years back. Actually, it's going on 8 years back at this point, but it's still valid. The things in yellow are how critical they are to employers, and the things in sort of the brownish color are the percentage of respondents that it's not a problem. So healthcare and health insurance for small business, if you don't know this is extremely expensive, and it is usually a problem of some level or another. Uncertainty about the economy, given the current environment, yeah. If you watch the stock market in the last week, you'll understand what that means. Cost of fuel, government actions, concern over what the government might do on certain things, and regulatory environment stuff, taxes. These are all the kinds of things that bother people. So, all right. This is a big concern for a lot of business: antitrust. Antitrust is another way of saying anti-monopolies. So these were put in the late 1800s and early 1900s, kind of a Teddy Roosevelt era kind of thing. The big deal here is you cannot compete in such a way that you purposely put your competitors out of business without economic. So, for example, if you were manufacturing, name it, TVs, right? And you could manufacture the TV for $100 at cost, but you're selling it at $50. You're selling the TV for $50, so it's $50 below your cost. Why would you do that? Well, if you're a big company, you might do that to drive all your small competitors out of business, and the moment they went out of business, you put the price back up to some sort of crazy number, and you'd own the market. So you cannot do things like predatory pricing. You cannot purposely restrict trade and prevent small businesses from competing with you, or other businesses from competing with you. So it prohibits competing in such a way that you stifle competition. Now, that's not to say that you can't be aggressively competitive, but you can't do it in such a way that it seems illogical, except for the fact that you're trying to put your competitors out of business. So the Federal Trade Commission was put about 100 years ago, or a little over 100 years ago, was put into place to enforce these kind of things, to enforce bans and hazardous safety things. Okay, not what I really care about. Okay, fair labor standards, set a minimum wage, require overtime pay, A lot of things that unions were looking for. Civil Rights Act certainly was important as far as preventing discrimination. All right. Immigration reform control discourages illegal immigration. This goes back to the 1980s and even before that. Civil Rights Acts, okay. So this, let's go back to this one. Okay, this one is where we're going to start getting into, well, I should back up to this. From an immigration point of view, strongly encourage hiring immigrants, backbone of America. However, they have to have legal documentation. If they don't have legal documentation, this can be extremely expensive for the small business to cover the fines and penalties that will come from if they ever get caught hiring illegal aliens. So, as much as whatever your political leanings are on this, it's not really material. From a business perspective, if you hire people who are in the country illegally, it can be extremely expensive, so it doesn't make sense. Okay, next, Americans with disabilities. Now, this is broadly interpreted. So they show a guy here in a wheelchair, but it could be any kind of disability that we're talking about. It could be vision, it could be hearing, it could be a learning disability, it could be alcoholism is oftentimes considered a disability. So there's a lot of things that could be put under this very broad umbrella of disabilities. Now, the thing is if you're, there's a reasonableness standard to this law. So if you are a large company, you're a Google, you're an IBM, you're a AT&T, you're a GM, if someone comes and applies for a job, you have to make reasonable accommodations. If that means that you need to put in ramps outside your company or maybe even add an elevator to the building, that could be possible for a very, very large company. However, if you're 10 employees or less, the leeway that you have for saying it's not reasonable for me to build a ramp because it'll put me out of business, the cost of doing that because I'm a small landscaping company, and building a ramp to the second floor of my office building would be prohibitively expensive, so I can not hire the person with a disability. So it's reasonable accommodation. There is no such thing as you have to absolutely do this if this person applies for the job. No, it's reasonable accommodation. And the level of reasonableness is directly correlated to the size of the company. And there's a lot of things that do not apply to very small companies with 10 employees or less. That's a sort of a rule of thumb rule here. If you look at a lot of laws, they apply to companies that have got more than 10 employees, or there's some sort of stratification. Less than 10 employees, don't have to worry about complying. Between 10 and 20 employees, you got to do a certain level of compliance. Over 20 employees, and so on. So this is a level of reasonableness in this law. What would be reasonable accommodation for this person? You've got to go out and make the level of reasonable accommodation. Okay, Civil Rights Act simply said you cannot discriminate against someone because of their race, because of their gender, because of their religion, because of, at this point, there have been recent court cases within the Supreme Court that have suggested that the court may rule that you cannot discriminate against someone because of their sexual orientation. So this, essentially, you can't discriminate against people just because they're a member of a group. Okay, Affordable Care Act, so that this was the Obama administration stuff, so it's healthcare coverage. Okay, you have to have a certain level of healthcare coverage. You can buy it from the marketplace. Whether or not this will stay around in the second Trump term, I don't know, but there will be some sort of, likely be some sort of version of that as we go forward. Workman's comp, in case you get hurt on the job, you have to pay into workman's comp insurance. Unemployment insurance, if people are fired, they can claim unemployment insurance. However, they cannot claim it if they quit or if they're fired for cause. So if someone is stealing from you, they can't claim unemployment insurance. And you pay into that, so it could affect your premiums if someone is claiming unemployment from you. All right, OSHA, big deal. Okay. OSHA's Occupational Health and Safety Administration, or Safety and Health Administration, they try to create safe work environments, so they try to enforce laws that prevent people from getting hurt on the job. This is particularly important for industries like construction or manufacturing. Not a big deal for something like consulting. But it looks for dangerous things within the work environment that they're going to look for you to change. So again, things that could be physically dangerous are where this comes in most commonly. So manufacturing, construction, commercial fishing, something like that, where it could be physically dangerous to the people who are involved in the occupation. Okay. There's licenses, restrictions, permits. So licenses require at different levels. You can have a city requirement, you could have a county, a region, a state, a federal. So you might look at licenses and restrictions. So there may be, you buy a food truck, you may have to have a city vendor's license, okay? There may be a restriction against going to certain parts of the city and parking the truck. It may be a restriction for how long you can park a truck in a particular location, right? So there's all these restrictions that you could end up having. And if I know a couple of people in the class have family in the construction business. Literally, there can be dozens of agencies that you have to comply with when building a building. I think my brothers, when they build an office building on Long Island, have to comply with over 100 different agencies. So this is a big deal when you're depending upon the industry that you're in. Okay. Double check licenses and permit rules. Okay, this is all pretty common sense. Professional requirements and licenses. So there may be a professional license, such as let's say you wanted to be a CPA, that would be a professional license. There's regional overseeing of environmental regulations. There's local and county requirements to be put in place. So you should really check to make sure that you're in compliance with whatever rules for that particular industry. Okay, zoning laws. Okay, again, depending upon the place that you're in, this could be a big deal, particularly kind of business. So a lady down the street from me a few years back, she was a yoga instructor. Her husband set up a yoga studio for her in her house, and she started having people come to the house for yoga instruction. Sounds pretty normal, right? Well, the neighbors complained because of the cars parked in the street, and she was shut down because it violated the zoning law. You have zoning could be for certain types of businesses too. So you may be allowed to have a business in one location but not in another within the city. So if you're choosing a location, zoning laws becomes particularly important. And fines can be relatively heavy if you don't comply with zoning, where they can literally just come in and shut you down. So or they can make you rip something out. So you build something that doesn't comply to the zoning laws, and they can literally make you come in and rip out whatever you've put in. Okay. Bankruptcy. Okay, so there's different types of bankruptcy. One objective could be just to liquidate. The other objective could be to sort of reorganize. And so there's different levels. If you have Chapter 11 or 13, this could be either a business or an individual where you're going in and saying, I'm going to find a way to reorganize or repay my creditors. You may get some relief from the judge as to what you have to pay, or any penalties or interest payments that you might have to pay to these people. But it requires going to court and meeting with a bankruptcy judge to sort of approve your bankruptcy plan. Chapter 7 is they go in and liquidate your assets and give it to your creditors. And there could be different priorities of creditors. And I'm not going to get into we're not going to become attorneys here, but just understand there's a difference between Chapter 7 and Chapter 11 from a business perspective. Chapter 7 just means we're having some financial difficulties. Chapter 11, we're having some financial difficulties. Chapter 7 is we're done, and we're being shut down, and oftentimes forced to shut down. Okay. So this just breaks it out. So business assets are sold by the trustees appointed by the court. Trustees distribute the proceedings to the creditors. Leftover money is divided among the shareholders. So this is pretty extreme. Chapter 7 is pretty extreme. Most people start at Chapter 11 and then may voluntarily go out of business without even having Chapter 7. They could just go out of business and say that's it, right? The bad news is if you have given credit, say that you do trade credit, you're a wholesale distributor, and you give a restaurant credit for, I don't know, wine that you're selling them, but that restaurant goes out of business, you're not going to get that money. If you do get the money, it'll be pennies on the dollar. So have to be aware, if you're going to be in the business of granting credit, what this means to you. And also, if this is a business, you might think, well, the business has gone bankrupt and therefore it's just the assets of the business. In a technical sense, that could happen, where if you have an LLC or a subchapter S corporation, you can your own company that is a corporation. The problem is that most small business owners will sign personally for many things. So very often, if you go to Chapter 7, they could be coming after your house. They could be coming after your bank accounts. They could be coming after your savings. So this is a serious business. Okay. Contracts. All right. Contracts is when you have agreement. Contracts is when there is consideration. And contracts have to be legal. Those are some of the key elements of contracts. So we'll get into more of that in a second, but it's agreement between two or more parties. It does not require to be in writing. Now that's the big. If you have it in writing, it's better, because then there is no question as to what was agreed to. If it's not in writing, you'd have to sort of prove that there was agreement and what was agreed to. But a contract does not have to be in writing. Things that require contracts usually would be the sale of real estate, paying off someone else's debt, somebody that takes more than a year to perform usually, or sales of goods valued at $500 or more. Well, there's some places that don't necessarily good the book. You can certainly sell something that costs more than $500 without a contract. Okay, so I forgot one, capacity. All right, again. Contracts is an entire semester's long course in law school, so you're not going to become an expert here in 30 seconds. But you cannot have a contract for an illegal act, right? You cannot you cannot hold someone to a contract for an illegal act. So you may have an agreement that you're going to have to pay someone to murder somebody for you. That is an illegal act, right? That means that contract, if someone violates that contract, you cannot sue them for violating a contract for something that's illegal. So a contract must be a legal thing to do. There has to be agreement. And that agreement has to come with the ability to make that agreement. So this is why contracts cannot happen with minor children, because minor children do not have the capacity legally to agree to something. You cannot have a contract with someone who has Alzheimer's disease, right? They do not have the capacity to make the decision. You cannot make a contract with someone who is under the influence of drugs or alcohol. They do not have the capacity to make a rational decision at that point. So capacity is a big thing. Any consideration. I cannot have an agreement with someone where there is to purchase something for nothing, right? There has to be some sort of consideration. I have to give them something in exchange for this, right? So there's got to be some sort of consideration within the contract. There's got to be a give and take here. Okay. Breach of contract occurs when one party does not hold up his or her end of the deal. Intent of litigation is to put things back in order. So you can litigate the breach of a contract, and you can try to get people to do something about it. Now, usually there is a couple different ways you can solve breach of contract. One, there's compensatory damages, which means that somebody gives you money for the fact that they broke the contract. Two could be specific performance. You can force someone legally to do something. This is a little difficult because that has to be enforced, and by whom, right? So you can force something, or you can get an injunction, so you can prevent them from doing something. So that the court says you're not allowed to do the following thing. That's an injunction. Injunctions can happen fairly quickly, and injunctions can be put in place to stop people from doing something until you can litigate it. So it could be a step against somebody. Like for example, you have a contract with someone to buy their house. They've signed it. They've agreed to sell you the house for a specific price. Someone comes along after the fact and offers them more money for the house. They can't ignore you and sell the house. So what you can do is get an injunction against them on their sale. You heard they're going to sell it to somebody else. You can get an injunction on that sale, and then you can go and force them to make the sale to you based upon enforce the original contract. So that would be specific enforcement, right? You have a contract with someone to, I don't know, DJ at your wedding, right? And they don't show up. Not only could you sue them for the amount of the contract, but you can sue them for compensatory damages, the fact that they ruined your wedding, right? So there's different ways of solving the breach of a contract. So we'll leave it at that. Okay. Intellectual property laws. All right. So this is things that processes you have, designs that you have, things that you've written, artwork you've created, some sort of original expression. So unique products, symbols, logos, slogans, expressions. So there's patents, there's trademarks, and there's copyright. Now the book is wrong here in a few places, or partially right in a few places. So let's talk about the difference between patents, copyrights, and contracts. Patents require you to file with the Patent and Trademark Office, right? Requires a filing. Now, in many cases, it's probably a good idea to have an attorney help you with this. You can have a regular attorney. You can have these people who are patent-specific attorneys, which they didn't. You don't have to go to law school to be a patent attorney. You just have to pass the bar exam for patent attorneys. So it's a special type of attorney. Patents are not good for 17 years. They're actually good for 20 years. Now, it takes several years to oftentimes get it through, so maybe that's where they came up with the 17 years on average is how long you have it. But you can actually begin producing something while the patent is pending, being that you filed for the patent and therefore it is protected from that date forward if you're granted the patent. So, and let's see, American Invention Exchange. Okay. That is a case. Okay, so it used to be who invented it first, but that became difficult to kind of prove, and so it's who filed first. So, and if you look at history, there's a lot of cases where people have invented either the same thing or nearly the same thing at almost the same time in different parts of the world. There's huge arguments, for example, over who invented radio. There's huge arguments over who invented the light bulb. There's arguments against all of these things because they seem to have been around the same time. Different technologies were developing, and people who were aware of what was going on kind of like put pieces together and said, wow, if we put this together with this, then we'd have this, right? And so who would argue that I came up with that idea first? Well, maybe you did, maybe you didn't. But we know who filed first because once you go and file, it's stamped. This is when it's filed. Okay, another important thing about patents is, where are patents good? Patents are only good within the country in which you file. So let's take a situation where you patent something here in the United States, and someone in France decides, they saw it while they were here, like you're selling the product here, you've got a patent on it, they go home to France, they make the same exact thing and start selling it in Europe. Can you go after them? Well, Yes and no. You cannot immediately go after them. What you would have to do is in the French Patent Office, because we have a treaty between the United States and France. We're part of the same treaty group, actually. You would have a treaty that says, between the two countries, that says that we will recognize the prior art. So if you can prove that you had patented, or at least filed for a patent for it within the U.S. prior to this guy in France coming out with it, you can go to France, you can file for the patent, you can wait for that patent to process, you can wait for them to invalidate the patent of the guy who may have patented it in France, to say, no, you had prior art. You then can go to the French court systems and look for relief in court. So it's not an easy process. So typically you only patent in countries where you plan to market your product. Now, can you sue someone for patenting in a country where you don't have a treaty? Let's, for argument's sake, say that we don't have a treaty between the United States and China, and someone in China does this. Guess what? You can go and try to sue them in the Chinese courts, but since you don't have standing with a patent in China, there's a good chance that you might not win. Now, China has changed some of their rules to agree to recognize some U.S. patent stuff, but originally, going back about 10 years ago, this was an issue. So, if you patent, you've got a patent in every country that you plan on having marketed, and it costs you money to patent in those countries, and it costs you money to maintain those patents. Okay. There's a utility patent, a design patent, a plant patent. Understand that it can be just the actual doing of something, like, I don't know, you could patent the utility. You've designed something that allows you've designed the actual hoverboard from Back to the Future, right? A real one, like you can hover above the ground and fly around on it, right? You've designed that. That's a utility patent. If you design, I think the book described the design patent in an interesting way. They said if you designed a pen that looked like a fish, that but was acting as a pen, well, you can't patent the pen part of it, but you may be able to patent that it looks like a fish, kind of thing. So there's a design patent. And plant patents, don't worry about that for right now. But plant patents, well, we're not farmers, so it's not a big deal. But plant patents, you can literally design a seed. So you've bred these different plants together to get this hybrid corn, right? You can patent your version of corn, and you can actually sue people who violate your patent or your protection. So in big commercial agriculture, if you buy a patented corn from a big agri company, I don't know, Bayer, right? You buy the patented corn from Bayer, you plant it in your field, you save some of the seeds and replant it next year, you have to pay a royalty to Bayer, otherwise they can sue you for violating the patent. Okay. Things that patent has to be an invention that fits within those different classes. It has to be useful, it has to be novel, and it has to be non-obvious. Like, you can't patent something that anybody would look at and go, well, that's obvious. And that last one sometimes is a threshold that some people can't get over. Patent search is conducted by searching to see if someone's actually filed for a previous patent on something like this. And by the way, this non-obvious thing, this sometimes you would say things should be obvious, and they have patents. I don't know if you remember the BlackBerry, but BlackBerry paid, I think it was something like $600 million to a guy they call a patent troll. And what he did was he had found a guy who had patented years ago the idea of having email come to a small portable device. He just patented the idea. Most people would have considered that obvious. Whatever judge they had said, no, that's not obvious, and he granted the patent to this. And these guys had sat on the patent for years. I should say the patent office gave him this patent. The guy sat on this for years, eventually sold it to a guy they call a patent troll, who's an attorney, and he sued BlackBerry to get a settlement for it and got like $600 million from BlackBerry for violating his patent, which most of us would have considered to be obvious. So sometimes you can get away with patenting the obvious. Okay. All right, copyright. Again, this is where this thing is actually wrong. Copyright in the United States, what does it take? First off, unlike a patent, you do not have to file anything to have copyright. You can just claim copyright. Now you can file paperwork with patent, trademark, and patent office if you want, but copyright, you just have to say, mark on it that this is copyrighted material, and you have it. Do you have to go to that threshold? No. In fact, by just proving that you own, that you created it first and claiming copyright, you can have copyright. So, and the copyright is the life of the author plus 70 years, after 1978. So the life of the author plus 70 years. This says plus 50. I don't know where they're getting the plus 50 from, but life of the author plus 70 years is what a copyright is. So it's a lot different than a patent, and it protects any creative work. So it protects, like if you write a book, you can protect photography, you can protect sculpture, images, you can protect anything that you can protect. You can copyright music, right? So you can copyright anything that is a creative work. That is the definition of copyright. And so it's generally considered now that copyrights last about 100 years, because you figure 30 years after whatever the author lived to plus 70 years. So your grandkids will be getting checks on your copyrighted material. Right. Okay. Let's be clear. There's different definitions of brand than this in the marketplace. So everything that have in that brand falls under trademark law. So the name of a company, a term associated with the company, the symbol of the company, the design of something specific, combination of these elements can be trademarked. So you can trademark your logo. You can trademark Mickey Mouse if you're Disney, right? Saying that he's an image that is associated with the company. You can trademark a phrase. Years ago when Donald Trump had the Apprentice show, he tried to trademark "You're Fired." However, that was already a name and trademark for a company that was in the ceramics business. There was a small ceramics company that like a small ceramics shop where you could go in and make ceramic things, and the company's name was "You're Fired." So that was their logo, their trademark. So he tried to then buy it from them. But you can trademark by filing with the trademark office. Again, usually takes a couple $100 to do a trademark. It's not a highly expensive thing, and the trademark is good as long as you continue to use the trademark. So unlike a copyright or a patent, it doesn't expire. So in the case of Disney, for example, you would want Mickey Mouse as a trademark, not as a piece of copyrighted material, because they could last more than 100 years, right? So you wouldn't want that to go into the public domain at some point, if you're thinking long term. It's like we said, you have to file. There's protection of intellectual property. Now, here's the thing about copyrights or patents: you can lose them if you trademarks if you don't protect them. So if you know that someone is violating your copyright and you don't call them out on it, or you don't call them out on violating your patent, your intellectual property could end up in the public domain, meaning that anybody could use it. So you have to maintain. So this is why you don't patent in every country necessarily, because you have to maintain this in every country in which you decide to file this. So it is a expensive process. And this is what we talked about before, the World Intellectual Property Organization. So this is like 200 countries that are part of this, but not all countries are part of it. So if you have a small country, say in Central Africa, that violates your patent or your copyright, it's too bad. It's going to be too expensive to go after them. All right, so that was all of Chapter 10, and we'll continue this